Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline lawyer. I have gotten so many questions lately from brokers who are trying to help landlords either sell their property or do something else, raise rents, whatever. Questions asking me, what can the landlord do? And the answer to the question is, I have got no idea. I'm not going to answer that question for you in this video. I'm going to give you an idea of some of the questions that I've gotten, and then I'm going to tell you why neither you nor I can answer that question for the landlord. There is only one person who can answer that question for the landlord, and that is the landlord's lawyer. Hopefully their lawyer has some expertise in landlord-tenant law, because it is a confusing landscape of laws in today's world, and average lawyer is not going to be able to answer questions for a landlord to some of these questions. So here are some of the questions that I get most often. I want to give notice to a tenant because the seller is going to sell their property. How much notice is required? Under statewide law, the answer to that question is 90 days. But when you give that 90 days notice, you've also got to have an affidavit that talks about them selling their property, and then the property literally has to be put on the market with an MLS in the right number of days, and the seller has to evidence good faith, the landlord has to evidence good faith to sell their property. What's required of good faith? I hope you're not going to try and answer that question for a seller. And moreover, I told you what the state law requirement is. 90 days notice. I don't know what any local jurisdiction might require, and many local jurisdictions have their own layering now of property management laws. So how much notice is required before a landlord can give notice to a month-to-month tenant? Of course, if we've got a term tenant, somebody who's allowed to, who has a contract saying they can be in the property for another 6 months, you can't give them 90 days notice and move them out. But if you got a month-to-month tenant, state law says 90 days, but your local jurisdiction could say something else entirely. You've got to send your landlord, your seller, to legal counsel, let their lawyer tell them not only what notice is required, but what notice form has to be used, how it has to be delivered, and then what actions are required by the seller after the tenant moves out in order to satisfy this good faith requirement. Additionally, there could be some jurisdictions that impose on the seller an obligation to pay some relocation costs for the tenant when they move for this purpose. Again, seems like it should be a simple answer. It's not. Raising rents. What notice is required to raise rents, and how much can a landlord raise the rents? State law says that if it's a month-to-month tenant, the landlord has to give at least 60 days notice to raise the rents and doesn't set a cap on what the amount of increase could be. Could local law have a different requirement? Absolutely. If you give the wrong notice, or if you violate local law with respect to an increase in rent, could that trigger a penalty for the landlord? Yes, and it can be a big penalty. And if the tenant moves out because the rents increase, and then they get representation to find out that the increase wasn't lawful based on state or local law, then the landlord may owe them money even after they've left the property. Evictions. Can landlords evict tenants now? The statewide moratorium eviction, the ban on evictions, is over. It's no longer in effect. So statewide, there is there's laws that allow landlords to evict tenants. There's no longer a ban on that. But what does that mean in reality? Can we really evict a tenant? Well, yeah, you really can, but there are now processes that landlords have to go through, not only from the provision of giving notices, but then the process before they get to the court of offering or participating in a dispute resolution, trying to resolve the issue short of eviction. Why is there an eviction happening? Is it for lack of payment? With lack of payment, has the landlord offered a repayment plan? All issues that are very difficult to interpret, not only under state law, but even more so if there's a layering of local law on top of that. Brokers do not field questions for landlords about how they evict a tenant. They need to hire a lawyer. Remember that every indigent tenant in Washington state is now entitled to legal counsel. That means that every landlord should anticipate that every tenant is going to show up at an unlawful detainer proceeding, an eviction proceeding, with a lawyer. That means that every I must be dotted, every T must be crossed. If there is any misstep in any of the filings or the delivery of the filings or the pleadings that are prepared, that will be reason to send the entire process back to the very beginning. And landlord who thinks that they've already gotten so far in the process of evicting is all the way back to the beginning of having to deliver notices. You don't want to be the reason that they've committed an error. And then the last question that I've been getting on this topic is, late fees. Can we now impose late fees? As of December 31st, 2021, the statewide ban on landlords being able to impose late fees on tenants who fail to pay their rent is lifted. Statewide, there is no longer a prohibition on the application of late fees to unpaid rent. Could there be a prohibition at the local law level? Absolutely. If your landlord operates only under state law and violates local law by imposing a late fee, they will have a problem, and probably an expensive one. So brokers, do not answer that question for your landlord. Let's summarize this way. If you get a question from a landlord about what they can or cannot do with respect to their tenant, what are the landlord's legal rights, what are the tenant's legal rights, don't answer that question other than to tell the landlord you need to go talk to a lawyer. And you're welcome to ask me the question on the hotline, but you're going to hear an answer that sounds a lot like what I've just said on this video. I might tell you, to the extent I can, what state law says, but I'm going to layer that with, I have no idea what your local jurisdiction's requirements are, so do not give this answer to a landlord. Instead, advise the landlord to seek legal counsel, because that's the only advice you can do. Recall that your agency law duty to your client is to advise your client to seek the advice of an expert in areas that exceed the scope of your expertise. None of you, unless you are a landlord, tenant, lawyer specifically, none of you are expert. I am not expert in answering these questions regarding landlord-tenant rights. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtor member.